All rise. Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning and welcome to the Court of Appeals. Appreciate you being here this morning. I know the drive up probably was not that enjoyable because mine wasn't. I want to take just a few minutes before we get started and talk about the procedure that we utilize here today. I know for a fact we've got experienced practitioners here in court today, but I always feel better if we just basically run over the ground rules quickly. Each side gets 15 minutes to make its oral argument. If you're the appellant and you wish to reserve any rebuttal time, please request that from the court after you come to the podium and have introduced yourself, but before you begin your argument. Appellant may reserve up to 5 minutes of rebuttal time. Appellee gets no rebuttal time. The lighting system we have is, we think, helpful to the parties. It's on the monitor on the podium. When you begin your argument, the green light will come on. So long as the light's green, you got plenty of time. Once the light turns yellow, you're running out of time, and once the light turns red, you are out of time. And we ask that you please respect those time constraints. One very, very important thing, and I think it's becoming more important every day, is that all these arguments are being live streamed. Think about what you're saying before you say it. It's real hard to pull anything back. In fact, it's very impossible to pull anything back once you've said it because it's out there for the whole wide world. So just know that the arguments are being live streamed. Before we begin this morning, I want to introduce our panel. We have Judge Arnold Goldman from Memphis, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Ms. Angie, anything before we take up the first case?
No, Your Honor.
You may call the case, please.
Buchanan, Dobson, Dunavant versus the William B. Dunavant Jr. Revocable Living Trust et al.
Thank you.
Good morning, Your Honor. John Galwin with Bassberry & Sims for the petitioner appellant Buchanan Dunavant. I'm here today with my co-counsel, Bill Burns. He's with the law firm of Watson & Burns in Memphis. And then sort of seated behind him, Bill is at table here, but behind him is Will Rout, one of his colleagues at Watson Burns, who's on this case as well and was instrumental in the briefing of the case. We'd like to reserve 3 minutes for rebuttal.
3 minutes. Are you making the argument?
I am, Your Honor.
All right. You may proceed.
Your Honor, this is an appeal, as you know, from an order on cross motions for summary judgment entered back on August 23rd, 2023 by Judge Ronette Hurd in the Circuit Court in Shelby County. It's a breach of contract case. And there were several arguments on cross motions for summary judgment below that resulted in our appearance here today, but the primary argument that was advanced by the respondent was that the contract at issue in the case was too vague and ambiguous to be enforceable. The case started in September of 2020, and for over 3 years, the respondent took a different position, a contradictory position, that the contract was in fact clear and expressly acknowledged that the contract obligated their client in a couple of respects. This is evidenced a number of places in the record, but for example, on January 11, 2022, in a summary judgment briefing, they said, quote, This is not a complicated case, and it does not require any specialized knowledge of trust and estate law. The court has already determined the rights and obligations that petitioner and William B. Dunavant had under the 1975 marriage settlement agreement. And so that was the position in the case for a number of years as it went on. But last year, the respondent reversed course after losing on a summary judgment motion where they said that their client had met those obligations and that they recognized under the contract. And they argued for the first time that the contract at issue, the 1975 MDA, was, quote, confusing. It was contradictory. It was vague. It was, quote, uncertain. And then, despite their prior position that no expertise in trust and estate law was necessary in the case, they tendered an affidavit of a legal expert, William Harbison, an esteemed lawyer from Nashville, on trust and estates, who opined that the marital dissolution agreement was too vague to be enforced.
Mr. Coleman, what are the terms?
So that's the first thing I want to look at. The actual language of the MDA at issue, I think, is pretty clear and concise. And to set that up, and I'm going to hit two provisions, Judge Golden, for you that I think are the key that we need to look at. But the divorcing parents who entered into this contract had 5 children at the time between the two of them. And 4 of those were the older siblings that had 4 existing trusts at the time. And the youngest one, my client, Buchanan, Buck Dunavant, who was just a toddler at the time of the agreement, he did not have a trust established. And so there are a couple of provisions in the contract that the court had to interpret. One is paragraph 3A, and it says, quote, "It is acknowledged that husband was grantor of 4 trusts for the older children, which trust have as assets certain stock of Dunavant Enterprises Incorporated and other assets." And then, Your Honor, there's 3B, which says, "It is acknowledged that Buck was not born when the above trusts were created. In order to equalize the inheritance, husband has arranged to provide life insurance for his benefit. Husband will create an irrevocable life insurance trust to receive insurance proceeds for Buck's benefit. The trust will provide that from the first proceeds paid on death, the trustee will hold for Buck's benefit an amount equal to the average of the after-tax funds received from the other 4 trusts." So that's 3B.
So how do we interpret that when the assets that are in the funding for the other trusts were stock that the heirs didn't receive until they turned 30 years old? Are we supposed to? How is that supposed to be funded? Is it funded as each heir turns 30, and so you know what the amount is that they're getting, because the stock, presumably it's private stock as I understand it, has variable values during their lives until they turn 30, and then it'll have a value that you can fund with an insurance policy?
Yes, sir, exactly. So we hired an expert witness who's a forensic accounting expert. We were prevented from learning what the average after-tax value of the amount received from the 4 siblings was in discovery in the case, but after 3.5 years, we were provided at least the information on the redemption of the Dunavant Enterprises stock, Your Honor. So we could see from the stock ledger, or our expert, more importantly, could see from the ledger what the redemptions to those trusts were, and therefore see what the average after-tax value of that would be. And that defines, of course, the contract says that is what needs to be funded in this irrevocable trust for Buck Dunavant. And now,
Who's the trustee?
well, the trustee is going to be named in the trust that Mr. Dunavant was contractually obligated to create. So the whole point of the case is that he breached his contract by never creating the trust.
I mean, the previous paragraph, the 3A gives you that information. It tells you who the trustee is. It tells you what the funding is, how it's to be done. And 3B does seem to be a little short on facts.
Well, Your Honor, I think that there's ample case law that we've pointed out to the court that speaks to this very issue that you're asking me about. And a couple of cases that come to mind are the Tennessee Supreme Court in Prince versus Prince, which said in an MDA that the husband needed to purchase life insurance for the benefit of the wife. But it didn't say what type of life insurance. Was it whole life? Was it term? Who was the carrier? What was the policy number? What was the amount of the insurance? There were vagueness in the MDA, but the Supreme Court said that that was entirely enforceable, that those details were not necessary in order to constitute an enforceable contract. We went back to 1932 to a Western Section Court of Appeals case, Neuberger versus Neuberger, which was an MDA interpretation case where the husband, Mr. Neuberger, had to provide, according to the MDA, for the health benefit and welfare of his 2 minor children after the divorce. But it didn't say how much he had to fund per month, who the guardian, there was going to be a paid guardian, what they were going to be paid, who was that person going to be. There were all these unknown terms in it, but the Western Section, in this case, cert was denied by the Tennessee Supreme Court, held that that MDA was entirely enforceable, that it was not too vague and ambiguous to be enforceable, and if you look at it like a recent case before this court, such as Glenn versus Ford, the Dyer investment case over the Lennox Lewis case, you know, there were terms in there that were lacking in the contract, but this court found that it was a fully enforceable contract despite that vagueness, and pointed out some important tenets of contract construction interpretation, and that is, quote, a finding that a contract is sufficiently definite is favored under the law. Courts will seek to avoid finding that an agreement is too uncertain to be enforced. The court will usually imply a term requiring performance within a reasonable time under the circumstances. So that the case law in Tennessee, Your Honor, certainly supports very strongly the enforcement of this contract. And so if Your Honor's concerned that, well, 3B is a little bit, you know, hard to interpret, if you look at the construction of contracts under Tennessee law, it is enforceable. I mean, if you look at those cases, I mean, that indicates to me that this is an enforceable contract. And certainly, if we had been permitted to do discovery, if we never got to see the trust, the sibling trust, that you're talking about, well, they got the money when they were 30. Well, we don't really know that in the record because we didn't get to see the trust. We're asking this court to reverse the summary judgment for the...
Why would you need to know that in order to determine whether or not this trust is enforceable?
Well, we don't know, for example, Your Honor was honing in on a fact which may not be a fact about whether they received something when they were 30. The stock redemption documents may indicate that monies were received at other times. These people are now much older than 30 years old. My client's in his 50s, and he's the youngest, but we never even got to see the trust of the siblings, which defines, I mean, we never got to see what was funded into those trusts and so forth. And certainly, we were not allowed full discovery on the average of the after-tax amount received from those 4 older siblings. And Your Honor, I have a protective order almost in every case. Almost every case I handle from a litigation standpoint has confidentiality concerns between the parties, and we enter a protective order. I understand the privacy interest of these people, and I respect it, but there are ways to deal with this so that we can get the information so that Your Honor would know precisely what the answer to the question is. What is that amount that they got? So what then did Mr. Dunavant, what was his contractual obligation to fund in this case? Well, we were kind of prosecuting this with at least our right hand tied behind our back under the circumstances by not seeing all that stuff. You know, we're responding to, statements in a 2007 revocable trust that we never even got to see the whole trust document. That's the kind of discovery limitations we were faced with, and that went on, for 3.5 years. So we're asking the court to reverse the summary judgment for them. I think there's clearly should be summary judgment on the issue of liability for my client, because there was an obligation to create an irrevocable trust. It wasn't created. There was an obligation to fund that trust. It wasn't funded. And let's go back and have a trial on damages, and the only thing we need on remand is to open up the gates of discovery so that we can have that information and put those facts on as evidence at trial, Your Honor. So with that, thank you.
Hear from the appellee.
Good morning, Your Honors. My name is Matthew Geel, and I'm with Birch, Porter & Johnson in Memphis, Tennessee. I'm here on behalf of the estate of William B. Dunavant, Jr., as well as his Revocable Living Trust. I'm joined today by my co-counsel, Jeff Feibelman, who's my partner at Birch, Porter & Johnson, as well as Blanchard Toole at Toole Graves in Memphis, Tennessee. This case involves an illusory promise found in a poorly drafted 1975 marriage settlement agreement, or MDA, as we've referred to it throughout this litigation. It also involves a son who gave his father every reason to disinherit him. We ask that this court affirm the lower court's determination that the contract provision at issue, paragraph 3B of the 1975 MDA, is simply too vague and uncertain to be enforced. We ask that you reject the petitioner's attempt to rewrite that language in a way that is contrary to the plain language of multiple provisions of the 1975 MDA. Alternatively, if this court finds that paragraph 3B is enforceable, we ask that you affirm the lower court's alternative ruling that Mr. Dunavant, according to the language of the contract, had the right not to create the trust established or discussed in paragraph 3B of the 1975, so long as he had non-arbitrary reasons to do so. The undisputed facts in the record are clear that Mr. Dunavant had numerous reasons to disinherit the petitioner.
If he wanted to disinherit him, why did he create the 84 trust form?
Your Honor, that was a 1984 life insurance trust that was created for the benefit of all 7 of his children. And I think you're right. I think ultimately there was no disinheritance here, and that he did provide for his son. And I think when I say disinherit, I mean under the contract. The contract at issue here involves the inheritance of Buchanan, Dobson, Dunavant, and what that means under this specific 1975 MDA. It talks about, in the heading of children's inheritance, that's paragraph 3, and then paragraph 3B, the actual heading is inheritance of Buchanan, Dobson, Dunavant. And if you look at the language contained in paragraph 3B, it talks about the purpose of this being, quote, in order to equalize the inheritance. And so when I talk about the inheritance and his ability to non-arbitrarily disinherit the petitioner, I mean as the parties contemplated under the 1975 MDA. And paragraph 3D obviously gave him the ability to do so long as it was non-arbitrary. I want to address some of your concerns, Judge Golden, regarding the vagueness and uncertainty involved in this contract. You're absolutely right that paragraph 3B doesn't identify a trustee, and that's in direct contrast to paragraph 3A, where there's not only a trustee identified, but a successor trustee identified. In addition to the lack of an identified trustee in paragraph 3B, there's also no timing for the distributions from this trust. There's no statements about whether or not the trustee would have discretion and whether or not the trustee would have actual standards in place for the distributions from this trust that was created. It was undisputed at the trial court level. We presented the expert opinions of William Harbison, who's an expert in trust and estates and deals with contracts that call for the creation of those types of legal instruments. Mr. Harbison has much experience, which I won't regale you with, that is discussed in the briefing, and his CV, which is in the record. Mr. Harbison looked at this contract and noted the deficiencies, that there is no trustee identified, that there are no standards, that there is no timing, the how, the when, the if of this trust. It's just not there. And the petitioner has taken the position in the briefing especially that Mr. Harbison's opinion can't be considered. It shouldn't have been considered by the trial court, and your honors shouldn't consider it. But they missed the mark. In any contract case that you have where you have a specialized subject matter, it's appropriate to have experts to testify as to the meaning of those terms and the types of terms that you would normally see in a contract. It just so happens here, the contract that we're dealing with has a subject matter of legal instruments like trusts and estates. And so Mr. Harbison, while you don't need to accept Mr. Harbison's ultimate conclusion that this contract is uncertain and vague, there's no doubt that his opinion about the types of terms that are missing from this contract is relevant and can be considered by this court. In addition to the issues with the lack of trust terms, there's also no information about the life insurance. There's no amount of life insurance specified, and there are no policies that are identified. Mr. Galwin, while he was up here arguing before your honors, he mentioned the Prince v. Prince case, which is a 1978 Tennessee Supreme Court case, which can be found at 572 Southwestern 3rd, 908. Now, in that case, I think Mr. Galwin left out some of the key facts. It involved a divorce decree where the husband was required to continue paying premiums on life insurance policies. And Mr. Galwin was right that the court identified, and I quote, that this agreement was somewhat indefinite. That can be found at page 909 of the opinion. They reiterated that at page 910 of the opinion, where they noted that there was no type of policy specified, that there was no carrier of the insurance specified, no policy numbers, or other information that you would normally see in contracts dealing with life insurance. The key fact in Prince v. Prince, where the court said, this is borderline on whether or not it's too indefinite to be enforceable, well, the tiebreaker, the reason why the court ultimately found an enforceable obligation in Prince was because they actually identified an amount, $30,000 of life insurance. That was in the contract. The husband actually transferred those policies to the wife and continued to pay premiums on those policies until the wife remarried. So in that case, when the court looked at a somewhat indefinite contract because of those terms missing, the only reason they were ultimately able to find an enforceable obligation is because they had an amount, which we don't have here. There is no amount of life insurance specified, and there are no policies specified. And for those reasons, it's just simply too vague and uncertain to find an enforceable agreement based on paragraph 3B of the agreement. Now, the petitioner attempts to rewrite the agreement in order to make it less vague, to make it more certain, more definite, and thus enforceable. But in doing so, he ignores the actual language of the agreement. First, paragraph 3B discusses how the husband has arranged to provide life insurance for the petitioner's benefit. It discussed how the trustee will hold for Buck's benefit an amount equal to the average of the after-tax funds. And I think that goes to one of the points that you asked about, Judge Golden, when Mr. Galwin was arguing. They talk about distributions. They talk about anything but the actual language, which is funds. And of course, we're comparing apples to oranges here because, as you noted, the corpus of the other trust, the siblings trust, well, that was Dunavant Enterprises stock, a closely held private company where the stock was variable. And so they try to change it to make it make sense by talking about average after-tax distributions or redemptions. But they also change the language and say that upon Mr. Dunavant's death, the petitioner would have been entitled to receive insurance funds. But again, that's not what the agreement says. The agreement says that the trustee will hold funds for petitioner's benefit. And the reason that's important is because it goes back to what we have where we don't have those trust terms and those distribution terms and what the standards and timing for distribution. So all the agreement would have required would be for the trustee to hold funds for Buck's benefit. There's no obligation that the trustee would ever have had to distribute it, or that Mr. Dunavant's son, the petitioner, would have received any funds. And I think that's what makes this more like an illusory promise, or an agreement to agree, which of course are not enforceable under Tennessee law. But I think the most egregious part of the petitioner's argument, and I'll say I was a little surprised that kind of the way he framed his argument, and that he agreed with your question, Judge Golden, that it would have been timed at the time that the trust terminated, when that stock would have been turned over to the siblings. Because the position that they took consistently at the trial court, and the position that they've taken in their briefing, is that they actually would have needed to look at all of the distributions that had been made to the older siblings from their respective trust up to the date of Mr. Dunavant's death. And that's an absurd obligation. And not only is it absurd logically, but it's against the express language of the 1975 MDA. Paragraph 6A, which is titled Life Insurance, states, husband, Mr. Dunavant, shall have no further responsibility with regard to life insurance except to A, maintain the life insurance that had already been arranged above described. And so their obligation and the argument that they've made is that this would continue and that they'd have to keep track. Well, that's an absurd obligation, because that would have required Mr. Dunavant to check the stock, keep up with every single distribution that had ever been made, and then buy life insurance accordingly. And that's against the express language of the agreement. And so we would ask that you would affirm the lower court's decision that the agreement and the provision at issue here is simply too vague and uncertain to be enforceable. Alternatively, if you do find that there is an enforceable obligation under paragraph 3B, we would ask that you affirm the lower court's decision that Mr. Dunavant had the right and the ability not to create this trust so long as he had non-arbitrary reasons to do so. And that's because paragraph 3D of the agreement must modify paragraph 3A. The courts in Tennessee have been clear and consider Cocke County Board of Highway Commissioners the Newport Utility Board, which can be found at 690 Southwestern 2nd, 231, and it's a Tennessee Supreme Court case from 1985. In that case, the Supreme Court told Tennessee courts that they must consider the entire contract. They looked at headings to determine how the different provisions interacted and how they qualified each other. Well, here, as I discussed earlier, in response to your question, Judge Golden, it's clear that the contemplated inheritance under this agreement was this trust. And so in order to give meaning to paragraph 3D, that Mr. Dunavant was not going to arbitrarily disinherit any of his children, well, the only way to read that in a way that doesn't render it surplusage, which is something that obviously Tennessee courts have warned against in reading contracts, is to say Mr. Dunavant had the ability, so long as he had non-arbitrary reasons to do so, to not create that trust. And the trial court was clear that Mr. Dunavant had this obligation to create the trust, and he had up until his death to do so. And so Mr. Dunavant had all of that time to make that determination. And so we've put numerous facts into the record as to why Mr. Dunavant could and did non-arbitrarily disinherit his son, the petitioner, as considered under the contract. And under Tennessee Rule of Civil Procedure 56.03, I mean, there is a specific procedure for contesting undisputed facts. You can admit them for summary judgment purposes, or you can dispute those facts with specific citations to the record. We don't have that here. We put in facts from Mr. Dunavant's trust, wherein he laid out the reasons for why he didn't create this trust. And there were numerous reasons. He noted that he had provided for the petitioner in many ways during his lifetime, that he gave him all the benefits and privileges of wealth and an affluent lifestyle. He noted that he had given his son, the petitioner, millions of dollars, both in loans and investments, much of which was ultimately forgiven. And in response to those undisputed facts that were properly put before the court, the response of the petitioner was to say that he had, quote, insufficient information to affirm or deny the facts, or to say that he didn't believe, quote, these alleged facts were relevant to the resolution of the pending motion for summary judgment. That can be found at the record at volume 28 at pages 3,580 through 3,582. These weren't proper denials by the petitioner, and as such, these facts are undisputed. In addition to all of the things that Mr. Dunavant provided to his son during his lifetime, he also had reasons not to leave him anything else. Mr. Dunavant's son, the petitioner, caused significant legal troubles for Mr. Dunavant. When he was in high school, the petitioner punched another student in the face, broke his jaw, caused significant legal expenses to be incurred, and ultimately he had to pay a settlement. Mr. Dunavant had to pay a settlement on behalf of his son. In addition to that legal trouble, there were also legal troubles that involved the Commodity Futures Trading Commission, wherein the company that Mr. Dunavant owned, Dunavant Enterprises Incorporated, lost millions of dollars in fines, attorney fees, and related expenses. Again, the petitioner did not properly dispute these facts and stated again that he had insufficient information to either affirm or deny the facts. As a result, these facts are undisputed, and the record is clear that Mr. Dunavant had the right and he had the reasons to non-arbitrarily decide not to create the trust at issue. We'd ask respectfully, Your Honors, that you'd affirm the trial court on both reasons that the court gave for granting summary judgment in favor of the respondents. First, that the contract was too vague and uncertain to be enforceable, and second, that if you do find an enforceable obligation, that Mr. Dunavant had the right and the ability under the contract to do so, to not create that trust for non-arbitrary reasons, which the record is replete of. Thank you very much. I appreciate my time, and thank you, Your Honors.
Thank you.
Just to address a few things that were brought up by counsel for the respondent appellee that I didn't hit on in my argument before. Mr. Dunavant could not revoke his contractual obligation to create an irrevocable trust, as respondent suggested in his argument, and in his brief for that matter. Respondent argued that Mr. Dunavant had a right not to create the irrevocable trust based on language in the MDA stating that Mr. Dunavant was prohibited from arbitrarily disinheriting any of his children. Since Mr. Dunavant was prohibited from arbitrarily disinheriting any of his children, respondent then asserts that he could non-arbitrarily disinherit Buck. But since he could non-arbitrarily disinherit his children, respondent's counsel argues he simply could choose not to fulfill this contractual obligation. Well, if you follow that, Your Honor, it renders the whole provision in Section 3 meaningless. He has a contractual obligation to create an irrevocable trust. If you step back for a minute, this is a situation where a husband and a wife are getting divorced. 4 children have these trusts. I'd love to confirm and see them that they were irrevocable trusts. I think they were. And she's making a big statement by saying, I'm going to go to bat for my youngest son and make sure he gets an irrevocable trust as well. But the key word there is irrevocable. So there is a provision that says that he can't arbitrarily disinherit any of his children. But to use that to say that an irrevocable trust is really revocable, or stated another way, well, I'm relieved of my obligation to ever create this irrevocable trust because I have a non-arbitrary reason. But that leads to the second point, that none of those things are properly in the summary judgment record that he says are the non-arbitrary reasons for not creating the irrevocable trust. A fight when he was in high school and so forth. Well, all of that's barred by the dead man statute. It's all hearsay. If you look at their statement of undisputed facts, Facts 1 through 16 are all things by Mr. Harbison saying that the MDA is not enforceable because it's too vague. Facts 20 through 24 are admissible testimony of DEI, Dunavant Enterprises employee David Herring, about the irrevocable trust of the 4 siblings. He's telling us what's in those 4 trusts that we weren't permitted to see. None of that's admissible. It's hearsay. Facts 25 through 39 of their statement constitute a joint affidavit from Mr. Cherry and Mr. Earhart, the 2 personal representatives of the estate, saying, here's what is in this revocable trust of 2007 as amended, and here are these reasons where Buck Dunavant could be non-arbitrarily disinherited. Well, a couple of men signing an affidavit about what's in a document that we haven't even seen the full document of in discovery, that's not properly in the summary judgment record, and to rely on those things, we say, was a real error below, and shouldn't have been considered, and shouldn't be affirmed at this point. So, thank you.
Thank you, counsel. We will review the record. We certainly appreciate your argument, and we will attempt to get you an opinion at the earliest possible time. May be excused. Thank you.